Good morning, I'm Dan DeRose with 19 News, coming to you from our digital desk. We're going to be taking you to the Justice Center in downtown Cleveland here for the sentencing of that man right there, Sir Truce Bender Adams, just 29 years of age. This murder took place back in July of 2022. Sir Truce, that's his first name, has been found guilty by a jury of aggravated murder, aggravated burglary, and felony assault, as well as having a weapon under disability, meaning he was a felon in possession of a gun. He is guilty of the murder of Quimonte Leonard. As you saw, there are a number of Leonard's family members in court. In the state of Ohio, we have what's called the victim impact statement portion of the sentencing. Family members can get up and let the judge know how this has impacted their life before the sentence is handing down. Let's take you live now into the courtroom of Judge Ashley Kilbane.
And we set this matter for sentencing today. I have reviewed the impact statements from the victim's family. Is there anyone from the state and defense that intend to speak today?
Yes, Your Honor. I believe there's going to be 3 individuals from the victim's family that will make statements.
And from Mr. Bender Adams's?
Yes. Just the defendant, Your Honor.
Okay. All right, then I'll allow the state to proceed.
Thank you, Judge. At this time, Your Honor, we would have
one at a time, please.
Robin, R-O-B-I-N, Simmons, S-I-M-M-O-N-S.
Ms. Simmons, what would you like to know?
A bad man shot. A bad man shot and killed my daddy. These are the words of my 5-year-old granddaughter, Quimonte's daughter, Ariana. She wrapped herself in her daddy's blanket. She kisses her daddy's necklace. And she sleeps with her daddy's book. Judge Kilbane, the pain. The pain is deep. This is truly a living nightmare. Quimonte Marcel Leonard was doing everything right. Q was an upstanding citizen. Nothing less than a driver license speeding ticket. He was a keen businessman. He started his business at 19, built it, and expanded to 5 businesses. Owned his own property, owned his own house. He was a daunting father, but more importantly, he was my child. My only child. It was hard. It was hard to sit here and hear the testimonies and see the details of my son's homicide. The most gut-wrenching part to hear was when the accomplice claimed the murderer told him, I had to do what I had to do. Well, with that statement, I'm asking you to do what you have to do. Judge Kilbane, I'm asking you to give Sir Truce Bender the maximum penalty of each offense. Since the convicted murderer had to do what he had to do, then he should pay for the rest of his life. So when my beautiful granddaughter tells people a bad man shot and killed my daddy, she could also tell people that the bad man is in jail for the rest of his life and won't be able to get out and shoot and kill anyone else's daddy. Thank you, Judge Kilbane. Thank you for listening.
Thank you for your statement.
And holding my thoughts in consideration.
I will.
Good morning.
Good morning.
My name is Chester Leonard, Chestr, last name Leonard. 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 Okay. Your Honor, no parent ever imagines burying a child. It's not natural. It's almost as if it was a bad dream or nightmare. The only way I could even believe this was real, I had to personally clean up the blood from his home. That's what made it real for me. I thank God that my youngest son had got picked up that evening. Q essentially was the primary caretaker for his daughter, allowing her mother to do what she needed to do to better her life for her and my granddaughter. I never had to worry about my granddaughter, my son, or my daughter, because between me, myself, and his mom, the seeds were planted and watered so the roots were strong. And the bond he had with his little brother and sister was just as strong. Not only was he his daughter's hero, he was his brothers, his sisters, and his cousins as well. All the cousins looked forward to spending time with their cousin during family gatherings like Thanksgiving, Christmas, and cookouts. He was the future patriarch of the family. But it would be selfish of me to continue to talk about what he meant to our family. So let me talk about what he meant to the community. He was a mentor at the school he graduated from, Bedford Heights High School. He tried to show his peers that there was a better way and that you can have just as much, if not more, than people who commit crimes, selling drugs, robbery, etc. If you just get up, put your head down, work smart and hard at your craft. One of his favorite lines was, "Nobody is going to outwork me, Dad." We learned that on the football field and the wrestling mat. He had begun to meet with politicians in and around our ward. His vision for tomorrow's youth was so impactful that the councilman asked to speak at his funeral. Your Honor, while consecutive life sentences won't bring my son back, it will help to bring some form of justice to my family and some sense of safety and security to the community. So I ask that this would be the punishment for Mr. Bender, as he has killed a bright and shining light of our community and caused an eternal void in the lives of our future, of my current and future family members. Your Honor, I would like to thank you in advance for the consideration of a double life sentence for Mr. Bender, and thank you for hearing my voice.
Your Honor, my name is Brent Warren, B-R-E-N-T, W-A-R-R-E-N, and I am the cousin of Cumante Leonard. His father and I grew up as brothers in the same house, which made him virtually my nephew, so this is a close bond, and this hurts. Vicki Harrison is quoted as saying, "Grief is like the ocean. It comes on waves, ebbing and flowing. Sometimes the water is calm and sometimes it's overwhelming. All we can do is learn to swim." My family takes turns being saved from drowning in this ocean of grief. I've seen years stolen from our youthful faces. I've seen it in the form of things like sad expressions, smiles that are snatched away as we laugh and look for you to laugh with us, swollen eyes with dark circles and crow's feet, all resulting in an aged appearance of 5 to 10 years. The why behind this is nothing short of the actions of Sir Truce Bender Adams. And if it pleases the court, I'd like to give voice to the pain and suffering of Q during the final moments of his life on the morning of July 8th, as he's not here to speak for himself. On that day, Q woke up like he did every morning, ambitious, hungry for success, and driven by his vision to legally grow an empire. Amongst other things, he dreamed about how to expand his scrap yard, his Turo business, his car lot, his Airbnb business. And with my background in accounting and consulting that caters to companies with revenues exceeding $100 billion, he'd often bounce ideas off of me. So I can tell you, and I can attest, that he had some amazing business ideas, and he had a revenue growth model that worked. This man was set up for success. His dreams were to provide an abundant life for himself, his daughter, and other family and friends that were dear to his heart. Unfortunately, he envisioned a future that he'd never see, because Sir Truce Bender Adams decided that he'd torture, rob, and kill Q. As Mr. Adams invaded Q's sanctuary, he mercilessly sent 2 bullets ricocheting through Q's body, with one of them causing irreparable harm, causing him to fall to the floor where he lay in the pool of his own blood, leaving him in agony just past his front door. And in a grueling and horrific span of 25 minutes, our Q was fighting for his life, along with his assailant, as he mercilessly stepped over his body looking for material possessions that he could steal and claim as his own. In his sanctuary turned human slaughterhouse, Q would be held hostage by his attacker, not allowed to call for help, not allowed to leave home. He had to lay submissively to Sir Truce Bender Adams, even as he felt his life slipping away. For many of us, a throbbing headache, toothache, or back pain that lasts 25 minutes can seem like an eternity as we wait for Advil to kick in. Yet Q had to lay there for 25 minutes while his life passed before his eyes, while he thought about his daughter, while he thought about his parents, and while there was nothing he could do about it, while he waited for this man to leave his home, and he finally mustered up enough strength to crawl out his front door and fall on his front lawn. A man like that, who can treat another human that way, does not deserve to ever again see the light of day. And I concur with my family members in multiple life sentences, max sentence, whatever the case may be. Your Honor, this man has shown an irreverence for the police as he's seen mocking officers on a stolen moped. He's shown a reverence for the court as he sat here laughing through the trial. And I ask today, I entrust the court with our pain, our grief, and our plea for justice. May the court see the depths of our sorrow and grant us a semblance of peace through a just sentencing. Thank you, Your Honor.
Mr. Maver?
Thank you, Judge. I will be very brief. This court has had the opportunity to sit through a trial, so you know the facts, so I'm not going to belabor those facts. The only thing I want to point out to this court was the lack of remorse by Mr. Bender Adams throughout this entire process in the trial. His criminal record, as we're well aware, this is not the only case he is in on. He is also, he's in jail on another allegation of shooting and robbing somebody. So this is not the first, or hopefully the last time this would happen.
Well, so those are pending cases?
Pending cases, Judge.
With another judge?
With another judge, that's correct. I just ask for this court to take what you saw into consideration, the testimony, and more importantly, the wishes of this family, who have been here from the very beginning, and they're not seeing this to the very end. I can't put into words any better than what they did. So, like I said, I am going to wrap up here briefly. I would echo their sentiment and their wishes for a sentence. I believe that his history, the facts of this case, and his lack of remorse do require a maximum sentence in this case, Judge. And I would ask you to impose that sentence. Thank you.
Just to clarify so that everybody's aware and for the record, because I heard some of the people that spoke asking for a consecutive life sentence, the state and the defense agree that all counts merge except for 2, which is aggravated murder. That's 1 count of aggravated murder, and count 14, which is having weapons under disability. So the maximum sentence would be 1 term of life without, life without the possibility of parole, plus the 6 years of firearm specifications, which are mandatory.
That's correct, Judge.
Okay. Are you completed?
Yeah.
Okay. All right, Mr. Hoflick, on behalf of your client.
Thank you, Your Honor. First of all, if there's any pending matters that Mr. Bender Adams have, we would ask that you not consider that for the purposes of sentencing. He has entered a plea of not guilty on those. We're here for this matter alone.
So let me clarify that as well. So considering that for the purposes of sentencing, one of the charges, the weapons under disability, includes in the indictment that he was under disability because he had, with another judge, been given bond on 4 cases at the time, 4 separate times. So 4 separate times he was advised that he was not to have a firearm prior to this incident, and therefore it is a consideration because it's in the indictment, first of all, that he was found guilty of count 14, that he was under indictment. And also, consecutive sentences findings also allows me to consider the fact that he was under subsection 2929.14C4A, that he was awaiting trial or sentencing. So for those purposes, I would consider them, but not because there's no conviction. So, but for those purposes, I am allowed to consider those.
Of course, Your Honor. Understood. Thank you. And then the same as what the state said, and you heard the facts of the case. I think the one thing that I would point out is the jury determined that this crime was not committed with any prior calculation and design.
Yes.
And I think that's important for the purposes of sentencing. We certainly recognize the jury's verdict in this case. However, my client does wish to exercise his appellate rights. We have advised him that he does not need to address the court to preserve those rights. I do know that he wishes to address the court anyways, but I would ask you not to hold against him what you won't hear from these statements, because he does wish to pursue his appellate rights. We certainly recognize and respect the jury's verdict, however disappointed we are in that verdict. Thank you.
So, Mr. Bender Adams, your attorney advised you, and I will also advise you of your appellate rights as it relates to appeals and your right to an attorney, but your attorney's advised you not to make a statement at sentencing, but you wish to make a statement anyways?
Correct.
Okay, go ahead.
Your Honor, you've heard the evidence that was brought in on behalf of the state, and I'd like to dive in that real quick, briefly, before I dive into the more conclusive evidence. Your Honor, we were presented here with such evidence that was used against me, and the jury clearly lost their way. The whole incident is on camera, and the jury relied on 2 witnesses that the state used against me, and they're not credible. Your Honor, the accomplice stated...
So you did not speak with the jury members. You don't know what they relied on in particular, because they reviewed all of the evidence in this case. So do not presume to make an assumption about what in particular convinced them one piece of evidence over another.
Correct. Your Honor, the state relied on the testimony of Edward Harris, where he stated that I exited the house with a bag of weed in my hand. On video, there's no evidence of that. Your Honor, the state relied on Edward Harris's testimony that he gave me the gloves and that I went into the house. My DNA is not found on the glove. He stated that he picked me up from the house and took me to the victim's house. We have a picture of evidence of somebody in the driver's seat with nobody in the passenger seat. Your Honor, there's clear evidence that somebody was picked up from Mr. Leonard's address. State versus Williams, 2011, Ohio 4812, won't allow this to happen. Also, what I want to dive into is there was a piece of glove that was left at the crime scene. The murderer was wearing those gloves. My DNA is not found on that glove. We can all agree to that I will be or should be exonerated. That's a plain error. Criminal Rule 52B. And that allows you, since you have broad discretion, to overturn the guilty verdict in your jurisdiction or in this tribunal, that if my DNA is not used or is not present anywhere specifically on the glove, which both sides can agree to, the person who exited the victim's house is convincingly the murderer, and my DNA is not on the glove, since I was tried as the principal in this courtroom, I should be exonerated. And since that is not, and since that's
And let's be
conclusive.
clear, Mr. Bender-Adams, what was found was the tip of a glove.
Correct.
And there's many different possibilities of why, and the state went over them, and the jury agreed. The other evidence was overwhelming in this case. The cell phones, essentially, I mean, and you have mischaracterized the testimony, you've mischaracterized the evidence, and you're trying to extrapolate from that.
Not at all, Your Honor.
So I'm not done, Mr. Bender-Adams. Your phone and you were at that house.
Not
The
at all,
phones
Your Honor.
tracked you and tracked Mr. Harris from his house to pick up the car that was used back to your house. Then you see in all the crime cameras, and I disagree with you that you can't tell one way or another if there is or isn't because of the glare in the car. But you can see on various other cameras that there is somebody in the car. There's obviously two people getting in and out of that, or one person at least, which was you, getting back into the vehicle after the murder. And you can actually see everything in real time when you take into account the cell phones, the fact that your cell phone and you were at that location at the exact time of the murder. Every single second and piece and minute lines up, including with the real-time cameras. So, Mr. Bender-Adams, I could not disagree with you more about the characterization of the evidence in this case.
Your Honor, so again, briefly.
And if you'd like to file, this is your right for appeal. If you'd like to file an appeal, I'll explain that, but I'm not going to relitigate the evidence in this case. The jury has found you guilty. Is there anything that you would like to say before I sentence you? Because any legal arguments that you have can be submitted to the Court of Appeals.
Well, Your Honor, I should be exonerated because of violation of State versus Atkinson and Theo Mason versus the Appellate Court of 8th District.
And I appreciate you trying to cite cases, but when you did represent yourself, I can tell you that your understanding of those cases were mainly incorrect. So let the attorneys file an appeal for you. Do you have anything else that you would like to say as it relates to this crime that you have been convicted of, or to these crimes, I should say?
Yeah, also, real briefly, the co-defendant cashed out himself $1,000 from the victim's phone 2 weeks after he was murdered. Also, this is only for appellate purposes.
I'm wondering how you're aware that the co-defendant did that.
Evidence. Right. Thank you. So I should be exonerated. We'll let the 8th District decide this.
Okay.
Thank you, Your Honor.
Okay. All right. Anything else before I impose?
Nothing further from the defense.
No, Your Honor, thank you.
All right. The law states that I must impose 2 of the firearm specifications consecutively under Ohio Revised Code 2929.14, subsection B1, F, and G. So the 6-year firearm specifications on counts 2 and 4 will be run consecutive and prior to the underlying offense for count 2. So, Mr. Bender-Adams, I have reviewed the purposes and principles of sentencing. I have reviewed the statements presented, and I have to determine whether or not, or the nature of this crime, whether it's more or less as one of the factors of other similarly situated crimes. The one thing that I will say, and I think that was pointed out, if I'm not mistaken, Mr. Warren, is that when I watched and saw the ring cam video, and then you watch the body cam of the victim in the lawn of his home, which means that when you left that house, he was still alive. And there was no 911 call. You left a man fighting for his life who ended up being able to take himself from the house to the outside in an attempt to try to get help for himself. And to me, that shows, in addition to many other facts in this case, a lack of remorse. So I am going to, on count 14, sentence you to 36 months in prison, and in count 2, life without the possibility of parole. In count 14, the weapons under disability, you were on probate, or you were on bond with another judge in 4 cases. Case 668-501, 651-287, 671-367, and 657-811. And you were arraigned on 4 separate occasions. So on 4 separate occasions, another judge explained to you that you were under disability and you were not permitted to have a firearm. So it's not just one time that you were told, it was 4 times. So even though I'm giving you a life sentence in count 2, I do find that count 14 should be run consecutive, and I'm imposing that consecutive prison term because it's necessary to punish you and or protect the public from future crime. The consecutive sentence is not disproportionate to the seriousness of your conduct and to the danger that you pose to the public, and that's under subsection A. 1 or more offenses were committed while the offender was awaiting trial or sentencing, and it's in those cases. Now, because you have 5 total cases with another judge, you do have 446 days jail time credit on this case. I'm notating that, but I'm not granting that to you until those other cases are disposed of to determine how those are run and whether or not they'd be run consecutive. And then after those cases are disposed of, I will put in an entry at a later date to determine what your jail time credit is. I'm also going to explain to you your appellate rights, but the first thing I need to do is go over your notice of duties to enroll as a violent offender. You should have a copy in front of those. You've gone over that with your attorneys. Do you understand the duties to enroll as a violent offender?
Correct.
Okay. Then I'm going to sign these. Okay. So, Mr. Bender-Adams, you've been convicted of or pleaded guilty to a qualifying violent offender offense. And also, Mr. Hoflick, I explained to you prior to this that you had the right to file a motion that he was not the principal offender. And you have not done that because I'm assuming that there's no allegation. I understand that he's maintaining his innocence, but there's no allegation that he was not the principal offender. Is that correct?
Your Honor, the main reason is to preserve his rights to appeal.
Okay.
So that, for appellate purposes.
Okay. You are to enroll in person with the sheriff of the county in which you establish residency within 10 days of coming into that county. However, you have been given a life sentence, so you have to register annually and for 10 years. Do you understand that, sir?
Correct.
All right. You have the right to an appeal. You have the right to an appeal of your case within 30 days after the filing of the court's sentencing entry. If you are unable to pay for the costs of a transcript, the record, and all relevant documents required for the appeal, they would be provided without cost to you. If you are unable to pay for an appeal, you are entitled to have a notice of appeal filed without the payment of a filing fee. If you are unable to obtain counsel for an appeal, counsel will be appointed for you at no cost. Do you understand these rights?
Correct.
Okay. I'm also explaining, that throughout this entire process, I also reviewed the psychiatric reports as well, so that, in lieu of a PSI, I do know a lot more about Mr. Bender Adams that has informed my sentencing as well. So I did re-review those prior to sentencing because I am allowed to review everything that was in relation to this case, the statement by a defendant, and the facts in this case. And for those reasons, that is the sentence that I'm imposing. Anything else before we conclude?
No, Your Honor.
No, Your Honor.
Okay. Then you are remanded. You will not be transported until your 5 other cases are disposed of. Thank you.
Dan DeRose with 19 News as we watch the sentencing of Sertruce Bender Adams, convicted and found guilty of the murder of Comonte Leonard back in 2022. In July, we heard from 3 family members, very impactful about this young man's life, about his daughter that now has to live and grow up without her father. Very emotional statements. The judge, even though Bender Adams tried to get up and yet again profess his innocence and say that there was no evidence that he was in that car and that he was taken to the home, the judge disagreed. Really wasn't going to put up with any of his explanation, trying to retry this case. As you heard, he tried to represent himself, ultimately having to be assigned counsel. And now will have a chance at appeal. But he was given a life sentence with no chance of parole. The judge then, for good measure, tacked on 4 years after that, mainly because of the gun specifications, a felon in possession of a gun. But wait, he has 5 more cases of armed robbery that he has to face before he goes to prison. We're going to wrap this up. If we have any other breaking news, we'll bring it to you here on our digital properties. Our 11 o'clock news, a little less than an hour away on CW43. Then our noon news on Channel 19. Until then, I'm Dan DeRose with 19 News. Have a good afternoon.
19 News is everywhere. Download our CTV apps